Uh, Much obliged, Your Lordship. Your Lordship, this is Parul, Council. Your Lordship, this is Parul, Council number 1 on behalf of the petitioner in the case titled Rainbow Non-Profit Organization versus Republic of Replimento, who shall be dealing with the issue number 1 and 2 as framed by the Honorable Court. Whereas my co-counsel Satyam Singala shall be addressing the court with issue number 3 and 4. Prior to the commencement of the argument, the petitioner, with the permission of your lordship, would like to summarize the facts.
Please.
Indeed, your lordship. For the sake and brevity of the your lordship, the facts of the present case are that the Republic of Replimento is the largest democracy in the world, which consists of people from different strata of the society, and that makes the Replimento the country a secular, a socialist, and a democratic nation. It being a member of the United Nations organization has always tried to boost the economy and its image on an international platform. That the Republic of Replimento used to have a law which criminalized the unnatural sexual intercourse irrespective of the gender. The said law was being condemned by various countries, and the Replimento was termed as inhuman. That the decision that thereafter the highest court of the Replimento made right to privacy a fundamental right. That the decision as stated did not mention anything about the civil rights. Highest court of Replimento dismissed the appeal, thereby granting civil rights to the LGBT. The union keeps on opposing the various writ petitions across the nation to read the word person in Hindu Marriage Act and the Special Marriage Act to include people from the same sex on the ground that it is against the culture and ethos of the country. Now, the petitioner would like to continue with the issue first.
Please.
Your Lordship, the issue first which has arisen in the present case is that whether or not the Hindu Marriage Act and the Special Marriage Act 1954 can be read in a manner to include members of the LGBT community. The council would present her arguments in a fivefold manner. First of all, that the concept of marriage has been evolved. Your Lordship, council would submit that the concept has evolved in the modern contemporary world. As everything passes through different states, so does the marriage. Reliance is placed on the decision of Navtej Singh Johar versus Union of India 2018 10 Supreme Court 1. On para number 230, it specifically mentioned that with the passage of time and evolution of the society, procreation is not only the reason for which people come together or even marry. They do so for a lot of reasons. The whole reasons are companionship, emotional support, material affection, etc. Moreover, the respondents had rested its case on a mistaken understanding of the legislature intention. Respondents are left to retreat beyond the statute text, and they are at fault for ignoring the legislative purpose. And the legislative purpose of the act, which is the Hindu Marriage Act, is marriage. So it is submitted that right to marry has been recognized as a part and parcel of the Article 19 and 21 of the Constitution. Your Lordship, it is further stated that the proof.
Council, what is your prayer?
The council prays that the LGBT should be granted the right, civil rights, and they should be read in a manner that they should be included within the term person under the Hindu Marriage Act and the Special Marriage Act.
Council, there are some difficulties in doing that, because if the person is it's easy to say that you can introduce person as being gender neutral, but there will be a lot of complications because these acts were not designed for it to be gender neutral. So a simple act of interpretation might cause much more confusion.
Indeed not, Your Lordship. That's though are of the old enactments, but they cannot be read LGBT, though the LGBT was not recognized earlier at that time, but the scheme of the objective of the
council, what are the specific civil, civil rights you are seeking?
the right to marry, right to marriage.
Is it only that? Because by Navtej Singh Johar, you are allowed to cohabit.
Sir, right to marry specifically and all other rights also.
Like
All other rights emanating from the marriage, like right to maintenance, right to guardianship, right to maintenance, guardianship, adoption, like
but
all
don't you
other
think
rights.
these are issues correctly which have to be debated by the legislature or parliament? Is it within the competence of a court to analyze these issues? Because I'm not saying that there could be issues relating to, whether a mother is necessary for the upbringing of a child. These are studies which are not conclusive about parentage of same-sex parents bringing up a child. Doesn't that child have a right to be brought up by one father and one mother?
Your Lordship, under Section 5, it is specifically stated that marriage can be held. It's about two individual. Like under Article 21, it has been said that it's about two individuals.
Two individuals is fine, but you're asking us because the traditional one is these acts which you're referring to are based on personal laws, with the exception of the Special Marriages Act. And can we introduce as a court, this reform only in the Hindu Marriage Act, or will it have to be all across? Because then only Hindu men and women will have the right to same-sex marriage. Or they will have to go under everybody, all same-sex couples will have to get married under the special marriages. So what exactly are you asking for? And where is person? Which is the interpretation? Which section are you asking us to interpret the word person to mean Hindu, or to mean man or woman?
Your Lordship, Section 5 and Section 7, all the provisions related to Section 5 of the Hindu Marriage Act 1955.
Okay, there is a provision saying that the bridegroom has to be 21 years and the bride has to be 18.
Your Lordship, Section 5 also mentioned that marriage can be performed between any two Hindus and does not distinguish between based on sex or gender. The right to same-sex couples to marry should be recognized, like it is already recognized. It does not differentiate between homosexual or heterosexual. It uses the word any two without discriminating between the homosexuals. Moreover, we can't give any word, any interpretation which is static.
No, these are as generalities, they are fine. I'm not disputing that. But I'm saying that there will be a lot of confusion if we just if there are specific civil rights, like for example, right now, 377 has been struck down. It is no longer a crime, right? Now you want certain things flowing out of marriage. I don't think it is the right of marriage itself which is being claimed. Certain things like succession, adoption, and those are the rights you are claiming now, right? So why do you want it through these acts? Why can't it be given? If you have this thing, and can a court do that? Because you're going to cause a lot of confusion, because a court must also protect its own legitimacy. Whether we think it is right or wrong, it is still a minority opinion in this country, right? Can we make such social changes in society?
Your Lordship, there is no such act till now, like which would deal with the interpretation part, and Um, could your lordship repeat the first part of the question?
See, my question is simple. The majority of this country, by many surveys, does not support same-sex marriage as of yet. Even same-sex relationship are not supported in most of the country. You are asking a court to interpret it with a minority opinion and give that interpretation to an act, allowing a certain number of people. So the only way we can do that is we reinterpret one of the fundamental rights of an individual to be the right to get married, which I must add was specifically rejected by the Constituent Assembly. Okay, it was not, it was discussed and rejected. So is it proper for a court now to read that into an existing fundamental right?
Your lordship, but the majoritan view cannot overrule, like it cannot be upon the minority view. Though the LGBT community are in minority, but they form an integral part of the constitution. They form they form a part of the India. And the judgment of K.
Counsel, you're not
Putta's
understanding the exact this thing. See, for example, Navtej Singh Johar was absolutely correct. We struck down a provision of law which was affecting the rights of individuals. Right. In this case, you are asking us to positively add something to the law. Striking down, yes, we can strike down a law if it affects the individuality of a citizen. We can read the constitution in such a manner. Right. But you are asking us to give certain rights or this thing which flow from marriage and this thing which without a democratic legislature debating these issues. And actually private member bills were introduced, I think, and they were both rejected. Both times I think they were rejected by Parliament.
Your lordship, but the right to choose partner has been recognized as a fundamental right under Article 21, as stated under the case of K.
Choosing
Swami.
partners, I have no issue. Choosing partners, yes, you cannot decriminalize the choice of partner and this thing to that extent. This thing, but this is not technically the right of privacy. Marriage, by its very conception, is not this thing flowing from the right of privacy. It is to announce what is the concept of marriage. It's to announce to the world that two people are in a relationship. Right.
Your lordship, but by not including LGBT community, it would violate the Article 14 and it would fail the test of Article 14. As under Article 14, it is specifically mentioned that there must be intelligible differentia, which should be reasonable and unarbitrary. But the ability to produce, ability to procreate cannot be the only criteria which would distinguish the LGBT community from the non-members. So that is the main criteria to see that where if we do not include the LGBT community, the Article 14 stands to fail.
In the Hindu. Okay.
And it is a very it is a right law also that every fundamental right has to be read in a harmony, and the basic difference which distinguishes the LGBT community from the another non-members is that the ability to procreate, and there being no necessary mandate to which specifically state that there should be procreation. The LS difference is gone, and there is no rational basis in not reading the act as contended by the petitioners.
Okay. Now, Council, I hope you know that if you ask us to, by judicial diktat, to tell that the members of the LGBT community will be entitled for marriage, it means the entire gamut of rights from marriage, divorce, restitution of conjugal rights, right? All these rights will flow from that this thing. Now, will it not cause more harassment to the community? Because it is, everybody knows that this the way the state machinery works in matters of divorce or domestic violence itself is not sufficient, right? You're going to adopt a certain this thing. Why don't you just take what is there now, that it has been decriminalized, you are allowed to live freely, you are allowed to live openly, and this thing. But because I don't think, I mean, you will have to, in cases of domestic violence by a partner against against his partner, you will have the domestic violence legislation being operated against. And I don't think the officers of whoever will be applying those laws will become, I hope they will be, but I don't think they will be compassionate enough to understand same-sex relationships in this country as of yet. So it might cause more harassment to the community.
That is why, Your Lordship, the petitioners are seeking to to read down of the act, and the state machinery cannot be a ground to deny fundamental rights to the LGBT community.
Normally, I would agree with you, but in this case, you are asking for positive directions from this court by bypassing the legislature, which is parliament, whose proper function it is to this thing. So our higher threshold has to be crossed.
Your Lordship, but Article 15 of the Constitution also says that that there would be no discrimination. There should not be discrimination on the basis of sex.
Okay, fine. Any more arguments?
Indeed, Your Lordship. The council would submit that there should be a reasonable and unarbitrary, so that it must be said that there is which should be reasonable and arbitrary, but the ability to procreate cannot be the only criteria, and it is not reasonable.
I agree with you. I agree with you, but I'm just apprehensive that a court making such a direction might be premature.
Your Lordship, if the intention of the legislature was to include the word person deliberately, it would have done so, but the legislature has used the word specifically to be they have used the word person, and which includes LGBT community. The legislature have not used the word male, female, so the ambit is wide. And
Council, no, you're not getting what I'm saying. The original intent of those provisions, the legislative intent is very clear. It was men and women. Okay. It was not meant to address the LGBT community, because at that time it was still a criminalized offense in 1955 or 56 or whatever, whenever the acts were made. And this thing. But now that same-sex relationships have been decriminalized, I mean, I'm not sure whether this is rightfully the domain of parliament in a democracy.
But Your Lordship, the society is also changing. The court has recognized the judgment of Indra Samra versus VKB Samra, in which it has recognized the live-in relationship
Which judgment?
Indra Samra versus VKB Samra. Like it's a proof
of
of
which
evolution.
Court?
Supreme Court.
Which year?
2013. 15.
But you see, live-in relationships, yes, those are complications caused by Indian society. So sometimes this court has granted protection. It has recognized. I mean, it was never prohibited, right? The only thing which was prohibited was same-sex couples. That has been decriminalized.
But Your Lordship, reference can be taken because it's a proof of the evolution that the court is also trying to interpret and widening its scope of the LGBT community.
Okay, next.
Your Lordship, the right to choose partner, as stated, has been recognized as a fundamental right, and moreover, there is no necessary mandate, and the main point is that an act has to be interpreted by taking into consideration the objective of the act. Your Lordship, though the present act, which is the Hindu Marriage Act, its objective should be taken into consideration. An act has to be read with consideration with the objective which it has came. Though the enactment of the Hindu Marriage Act is of 1950, but and that time also the LGBT community weren't there. But the act should be interpreted with context, with the objective with they came. And there is no bar on the homosexual marriages on any act and not bringing the LGBT within the Hindu Marriage Act, and that would run counter to the objective of the act. And if the legislature had the intention to exclude LGBT, it would have done so expressly. Like it would have done it expressly, stating so. That is why the councils seek that the act has to be read down, so to include the members of the community, unless the Article 14 would get violated. The council would proceed with the issue number 2. The council seeks permission. The issue number 2 which has arisen is that whether the civil rights should be granted to the members of the LGBT community or not. So the petitioner states that marriage is a civil right. Reference is given to the case of Indra Samra versus BKB Samra, in which it is stated that marriage is a civil right and it should be granted. And the civil rights are not concerned with sexual orientation. Civil rights are independent of sexual orientation. Non-conferring of the civil rights to the alleged to the community would be violative of the Article 14. And moreover, Your Lordship, the Article 14 of the Constitution, the Article 15, Article 21, and the preamble don't use the word male, female. They also don't use the word male, female. They use the word person. Though LGBT are in minority, but they form an integral part and they should not be deprived of the civil rights.
Is there any other specific provision apart from 14 that you're referring to in the Constitution?
Your Lordship, that would be referred by my co-counsel.
Counsel, just one question. For example, you have, see, Article 14 is not an absolute, right? There can be no absolute equality. That has been recognized by this court and this thing. But for example, the Hindu undivided family, right? That is one example of a law which is only applicable to Hindus, but it has been upheld as not violative of Article 14. Now, you have asked, your prayer, I presume, is only for the Special Marriages Act and the Hindu Marriage Act. Am I right?
Indeed, Your Lordship.
So how does this reconcile itself with non-Hindu marriage acts or between two same-sex partners who are non-Hindus? And how will the grounds of divorce be interpreted? Because there are some specific grounds of divorce which are only between, right, from the reading, it will only be applicable to men and women.
Your Lordship, that would come within the ambit of Special Marriage Act. But
so you're saying divorce will be under Special Marriage Act, then why doesn't all marriages under from say the same-sex community go to the Special Marriages Act?
no, only the marriage concept, like of the different, would come under the Hindu Marriage Act, not divorce, particularly.
Okay. Any more submissions, or your co-counsel will?
Now my co-counsel will proceed.
Okay, thank you.
Evening, Your Lordship. Am I audible?
Yeah.
Pleasant greetings, Your Lordship. Your Lordship, I would like to seek the liberty of the court to just supplement the contentions as have been put forth by my co-counsel with respect to the issue number 2, Your Lordship. Your Lordship, the issues which have been framed by this Honorable Court deals only with respect to the Special Marriage Act and Hindu Marriage Act. However, Your Lordship, issue number 3 and issue number 4 directly covers every religion, which the council shall point out in a while dealing with issue number 4, that how even the Muslim law, even the Parsi and the Christian should also be read down in such a manner so as to satisfy the fundamental rights of the LGBTQI community, Your Lordship. Your Lordship, sexual orientation cannot be made a ground for difference as has been prohibited under Article 15 expressly. Article 15 uses the word sex expressly, and Your Lordship, Nalsa judgment categorically says that sex would include sexual orientation, Your Lordship. Your Lordship, it has to be appreciated that the only difference between the LGBT community and the non-members is of the sexual orientation, Your Lordship. Your Lordship, for the purpose of civil rights, Your Lordship, LGBT community, Your Lordship, is necessarily divided into 3 categories, Your Lordship: men, women, and others, Your Lordship. Lordship, they cannot be denied the rights, Your Lordship, at least the civil rights, and which includes the right to marriage and every right emanating from that right to marry, Your Lordship. Your Lordship, now coming to issue number 3, that has been framed by this Honorable Court, whether or not the customs, traditions, rites, and rituals form an exhaustive code. Your Lordship, there were several petitions filed before the High Courts of the Republic of Replemento, wherein the Union has been taking the regular stand that the recognition of same-sex marriage is against the social ethos, Your Lordship. Your Lordship, it has to be appreciated that in the No.10 case, Your Lordship, the consensual sexual acts of the community have been legalized, have been recognized. Therefore, Your Lordship, there seems no reason to deny them the right to marry also, Your Lordship. Your Lordship, now custom, as have been contemplated by the Republic, they say that it prohibits the same-sex marriage, Your Lordship. Your Lordship, any custom has to pass a 4-fold test to be classified as a custom, which has been laid by this Honorable Court only. And several occasions, one such was Bhimsai versus Janabi in 2006, where it was held that undisputed long continuation and reasonableness has to be there. And Your Lordship, with the judgment of Sabrimala, Your Lordship, it is now settled that every custom has to pass the test of Part 3 of the Constitution. Your Lordship, Justice Chandrachud also in the Sabrimala judgment has categorically held that personal laws can be tested on the anvil of fundamental rights, Your Lordship. Your Lordship, the custom as have been contested by the Republic is irrational. How, Your Lordship? Your Lordship, the Republic says that majoritarian view is there against the same-sex marriage. However, Your Lordship, they are oblivious of the observation in the case, Puttaswamy case, Your Lordship. The council would like to take the court to page number 67 of the compendium, wherein para 144, Justice Chandrachud writes, majoritarian view cannot dictate the rights and liabilities of the present community, which is minor in number. Your Lordship, similarly, LGBTQI community, admittedly, being minor in number, though they are integral part, their rights, their fundamental rights, their legal rights cannot be taken away just because of some majoritarian view. Your Lordship, right to privacy.
Counsel, I agree with you.
Yes.
The 377 was taking away those rights.
Yes.
But here you're asking us to give a specific right.
Yes.
Right.
Indeed,
So,
Your Lordship. Your Lordship, non-conferring of the right, as has been correctly pointed out by co-counsel, would violate not only 14-15, would also violate Article 19, would also violate Article 21 of the Constitution, Your Lordship.
how is it 19?
Indeed, Your Lordship. Your Lordship, Article 19 provides for the association, Your Lordship. which has also been upheld. This contention with respect to this live-in relationship was also upheld by the Supreme Court, your lordship, in the Indra Samra case, your lordship. Your lordship kindly referred to Article 19, 1 subclause C, to form association. Now, this word association, your lordship, as has been understood by this honorable court only in the case of Indra Sharma, also contains the right to choose one's partner. It is also covered under Article 21, also under Article 19, your lordship. Your lordship, a custom must be viewed from the individual dignity, as has been held by in the Sabrimala judgment by Justice R.F. Nariman. From individual dignity point of view and substantive equality, we are thriving for the substantive equality, your lordship, under the constitution, which necessarily eliminates the discrimination on the ground of sexual orientation, your lordship. Your lordship, the union is not conferring the right to marry to the community just because of the sexual orientation. Your lordship, there is no reasonable basis to deny this right, your lordship. Your lordship, even if we take the right, even take the ability to procreate, your lordship. Your lordship, in Navtej Singh, the court directly said that procreation is not the only objective of the marriage. Your lordship, one more point, your lordship, when Navtej Singh allows for the companionship of the LGBT community, the consensual companionship, and also the court in Indra Samra case has recognized the live-in relationship, then the petitioner sees no reason to deny the right to marry also. Marriage is sacramental bond, and we also want to enjoy and reap the benefits of that bond, your lordship. Your lordship, fundamental rights are the most superior rights, your lordship, as has been held by a 7 judges bench of this honorable court in the special reference number 1 of 1964, wherein one Mr. Keshav was arrested and was put behind the bars on the violation of contempt of the Legislative Assembly of UP, your lordship. Your lordship, the court said that fundamental rights are most superior. And your lordship, every custom has to yield to these fundamental rights, as has been held in Shairavano case, your lordship, in Sabrimala case, your lordship. Your lordship.
Counsel, I agree, but see, how far can a court come into that sphere? Because then I mean, like we are being asked to review every rule, direction or legislation by parliament or the state legislature. We will be asked to review every custom, tradition, this thing. Then what is the point of having the freedom of religion? Because if this court has to get, we are not
your lordship,
men of religion who can answer those.
Indeed, your lordship. However, your lordship, the council would like to refer to Article 25, your lordship, of the Constitution. It says, subject to public order, morality, and health, and to other provisions of this part. That is part 3. Therefore, every custom, irrespective of it being a religious custom or any other custom, has to pass the test of part 3, your lordship. It is the duty of this honorable court, your lordship, to test whether the custom, as has been contested by this republic, is valid or not, your lordship. Your lordship,
with you on morality and health, but I do think that a positive direction from this court to all religious heads to permit marriages between this thing might cause an order to public order.
Your lordship, if the council understands rightly your lordship's question, your lordship is also at some point of time touching upon the separation of power concept along with this, your lordship. When the lordship said that the domain of the court, and your lordship, the public order, your lordship, it is settled law that every fundamental right, the entire chapter, entire part 3 has to be read harmoniously, your lordship. Just because of some public order, your lordship, the entire fundamental rights cannot be taken away from this community. Your lordship, also,
counsel, I am with you. I am telling you that if parliament were to enact a law saying that same-sex couples cannot get married, I would have no problem in striking down that provision.
Indeed.
Okay. But asking for all the rights from marriage and this thing to come on to the LGBT, I don't think that is the proper domain of a court.
Indeed, not, your lordship. Your lordship, in India, we do not follow, first of all, rigid separation of power, your lordship, as has been held by this honorable court in the Indira Gandhi case, your lordship. There is a separation of function, admittedly, your lordship. However, your lordship, the petitioner say the petitioner contends that if the rights are not being granted, are not being granted by this honorable court, then the constitutional validity of all these acts, the personal laws, whether codified or uncodified, would be in danger, your lordship. Your lordship, as has been pointed out, my co-counsel, Article 14, Article 15, 19, 21 are in danger. Your lordship, the court cannot wait, the court ought not to wait for any situation which would otherwise warrant the exercise of the power, your lordship. This honorable court has the ample power under Article 142 of the Constitution to pass the election. We are not seeking any amendment, your lordship. We are not seeking any enactment, your lordship. All we are seeking is the reading down of the rules, of the provisions, and the statutory sections to the effect that marriage of these same-sex couples and the members of the community can be solemnized, your lordship.
So, and that means you're also accepting that, I mean, the laws of divorce can apply to the LGBT community as is, without modification.
Your lordship, the contention here would be that reading down the meaning of word male, word female, bride, bridegroom, husband and wife is necessary. Your lordship, this contention of the council gets support from the judgment of this honorable court only in the case of, your lordship, in the case of Badshah versus Urmila, 2014 Supreme Court, page number 1110 of the compendium, wherein para 16, the court said that a change in social conditions should be respected and statutes must stand the test of time, and a purposive interpretation therefore is required to be done in the present matter also. Further, your lordship has a query from my co-counsel with respect to the parentage of the child. Your lordship, with respect to that, there is no mandatory provision or there is no mandate under the law that one should have a child. Also, your lordship, there are no studies which evidently says that a mother or a father singularly cannot help in growth of the children with same efficiency. Your lordship, also, when we talk about the custom as has been contested by the union, the custom has to yield to the fundamental rights. And your lordship, the most important point, no custom is there which bars the solemnization of the homosexual marriage, your lordship. There is no custom at all. They are just seeking the majoritarian view to be imposed upon the minority view, your lordship, which cannot be permitted in a democracy.
Counsel, if a religion claims that they do not recognize LGBT relationship between two individuals, can this court mandate that you must recognize them?
Your lordship, there are twofold submissions with this. First of all, because they are contending that there is a custom, the onus is upon them to prove that custom. Secondly, your lordship, even otherwise, Article 25 clearly says, your lordship, Part 3 has to be confirmed. Lordship, there was a Sati Pratha, lordship. That was also that was held to be violative, your lordship, by this honorable court.
But not by a court.
Your lordship, there was an act. There was an act. Indeed, there was an act.
So that is the correct way to go about it.
Indeed, there was an act, your lordship. Indeed, there was an act. However, lordship, the submission would again come to Article 25, your lordship. The intention of the Constituent Assembly in writing the Part 3 of this, the Part 3 in Article 25 clearly says, and also the same has been applied in the Sabrimala case, your lordship. Your lordship, there was a judgment of Narasu Appamali of Bombay High Court, which said that personal laws cannot be tested. That has been overruled, your lordship, by the Honorable Supreme Court in Sabrimala judgment only, wherein it says that yes, it can be tested, your lordship. The council are seeking the benefit of same. Also, your lordship, when we talk about issue number 4, which says that can the members of LGBT community be allowed to marry as per the right of as per their own religion? Your lordship, it is submitted that personal laws are either codified or uncodified. every codified personal law has to again pass the test of entire fundamental rights. Now, your lordship, even if we take, your lordship, the Parsi Marriage and Divorce Act 1936, Indian Christian and Marriage Act 1872, and uncodified personal law such as Muslim personal law, they have to be interpreted in a manner that protection guaranteed under Part 3 does not remain fruitless. Your lordship, that was same which was done by the Supreme Court in Shaira Bano case also. Your lordship, and your lordship, furthermore, every statute has to be construed in a manner to avoid any doubt with respect to the constitutional validity. Your lordship, every custom, every personal law, codified, uncodified, is covered under the expression law enforced under Article 13. Your lordship, there is change in social condition. When these acts were enacted, your lordship, the LGBT community was not even recognized, your lordship, but now it has been. It has been by this honorable court only. Therefore, the statute must stand the test of the time. Your lordship, the parliament or the legislature cannot be expected to anticipate every future situation. Therefore, purposive interpretation is required in the present case, your lordship. Your lordship, also, when the union has no problem in allowing the live-in relationship of a same-sex couple. Your lordship, when they don't have a problem with this, right, if they grant the right to marry, and if they allow the members of the community to reap the fruits of the sacrosanct bond, then there is no harm in that also, your lordship. Your lordship, along with the right to marry, every other right emanating from that ought to be granted also, so that the recognition of LGBTQ community, so that the decriminalization of section 377 can have their full effect, and just does not remain on paper, your lordship. Okay. Your lordship, yes.
Your next contention, please.
Your lordship, these are the contentions of the petitioners, your lordship, and your lordship, accordingly, your lordship, the petitioner prays firstly that the Hindu Marriage Act and Special Marriage Act shall be read in a manner to include members of the LGBTQI community. Civil rights ought to be and shall be granted to the members of community, because doing otherwise has no rational basis and has no rational nexus, and would also violate fundamental rights. That the custom, tradition, rites, and rituals, which has a common thread of custom in them, do form an exhaustive code for our community, or if the court is of the other opinion, they do not form the exhaustive code, as has been contested by the union. Also, the last pair would be that the members of the said community shall be allowed to be married as per the rituals of the respective religions, as there is no ritual, there is no custom which prohibits the same. Reference is made to the, your lordship, there are temples in Madhya Pradesh, Hindu and Jain temples in Madhya Pradesh, which actually depicts the homosexual activities. Your lordship, not only that, there are instances, the temples are Khaujoro temples, your lordship. There have been instances in the history, in the Mahabharata also, where we could see that homosexuality has
homosexuality is recognized and homosexual marriage are two different things.
Indeed, your lordship. However, with respect to issue number 3, which the union is contesting, as per the written submission, your lordship, is that homosexuality has been denounced, which is not the case, your lordship. Your lordship, with my marriage, what my neighbor has to do, it's my personal affair, your lordship. It is a part of my right to privacy. The social implications ought not to be seen, your lordship. Your lordship, jurist Austin has once said that a judge should not and ought not to consider the social implications of the judgments. The justice must be done, your lordship, being a positive society, because we are following the positive school of jurisprudence. The fundamental right should be given their full effect, your lordship. Now, with this point, your lordship, if the court doesn't have any other query, the counsel would like to rest the case and would seek the liberty for rebuttal and submittal at the appropriate time.
Yeah.
Much obliged, your lordship.
Can you just give me 1 minute?
Indeed, Your Lordship.
Yeah. Can we have the respondents now?
Am I audible, Your Lordship?
Yeah.
May it please Your Lordship, representing the respondents on behalf of the Republic of Replemento before this honorable court today, this is Aldrin Zothanmawia from Team Aldrin Zothanmawia and David Malsawmtluanga. With the permission of this court, I shall be reserving 15 minutes for addressing the first and second issues, and my co-counsel will address the third and fourth issues. And we would like to reserve 2 minutes for rebuttal. The respondents in this regard have submitted 4 major arguments to refute the claims of the applicants. I ask permission of the Honorable Court to proceed with the first argument.
Yeah, please.
Much obliged, Your Lordship. The first contention that the counsel for the respondents submits is that the Hindu and Special Marriage Act cannot be read in a manner to include members of the LGBTQIA community. Your Lordship, reading into Section 5, Subsection 3, and Section 7 of the Hindu Marriage Act, these 2 provisions stipulates that ceremonies for a Hindu marriage must be between bride and bridegroom, and this indicates that it pertains only to heterosexual couples. Your Lordship, when we look into the terminology of bride and bridegroom, it is defined as bride is defined as a woman who is about to get married or has just got married, according to the Cambridge Dictionary. And bridegroom is defined as a man who is about to get married or has just
Also,
got
there's no
married.
dispute. There's no dispute about these definitions as the original intent of these definitions. But since it has been held that same-sex couples have a right to live together,
Yes, Your Lordship.
right, and criminalizing such conduct is unconstitutional. So they are asking for the other rights which flow. Like why can't they get married? Why can't they inherit each other's property? Why
Yes,
can't they adopt a child?
Yes, Your Lordship. But specifically, they have disclosed that these two terminologies can be are gender neutral words. But however, we contest regarding that, and not only in the Republic of Replemento, but is a universal international interpretation. And this is the traditional principle of statutory interpretation, and these two definitions of bride and groom are gender conforming. With regards to Section 3A of the said Act, it implies the expression
Council, in
custom.
numerous acts, him has been read to include her. I think even the General Clauses Act includes that provision. So, those are not this thing which you need to waste too much time on. Okay.
Yes, Your Lordship.
Yeah.
Yes, Your Lordship. There is the expression used, customs and usage, which signify that any rule which have been continuously and uniformly used for a long time, since time immemorial, has obtained the force of law among Hindus in the local area, in the local tribe, community, or group or family, and the observance of these two terms as bride and bridegroom are customs and usages and have remains as an integral part of this Hindu society. Therefore, it is the traditional principle of statutory interpretation, and it attracts the provision of well-preserved custom and usage, attracts the provision under Article 26 of the Constitution of India, which pertains to right to manage religious affairs. And unlike when we compare and contrast Article 25 and 26, Article 25 talks about right to freedom to practice religion, but Article 26 talks about right to uh, administer its own affairs. Unlike Article 26, which is subject to other provisions of this part 3 of the Constitution, Article 26 is only subject to public order, public morality, and public health, and not to other provisions of this part 3 of the Constitution. So therefore, in a nutshell, it can be implied that Article the Article 14, 15, and 21 cannot be merely challenged. Article 26 cannot be merely challenged by Article 14, 15, and 21. Your Lordship, religious customs and practices cannot be solely tested on the touchstone of Article 14, and thereby it is humbly submitted as held in the court in Regina versus Secretary that the court should not embark upon the legitimacy of asserted beliefs on the basis of uh, morality as
Also,
contended
let
by
me
the
ask you a
petitioners.
hypothetical question. Can
Yes, Your
there
Lordship.
be a religious denomination which does not admit women?
Your Lordship, with regards to a denomination not admitting women, um, I have no knowledge regarding that. However, when we talk about the context of, since we talk about the context of the Hindu Marriage Act and the Special Marriage Act, when we read into these provisions in its current form, it does not imply to homosexual couples. It does not imply to the LGBT couples. And with regards to the Special Marriage Act, Your Lordship, we acknowledge that it is a secular legislation, However, in its present form, it applies only to heterosexual couples, wherein it uses the terminologies where it's male and female. This Special Marriage Act says that a male must complete the age of 21 years and a female the age of 18 years. Thereby, when we look into ideologies of Western ideologies, society of Republic of Reglamento and the intellectual differences must be observed as put forth in the dictum made in Jack Mohan Singh versus the state of Uttar Pradesh. Your Lordship, counsel for the respondents also put reliance on the Supreme Court judgment in Union of India versus Deoki Nandan Agarwal, wherein this court observed that the court cannot rewrite, cannot recast, it cannot reframe the legislation for the very good reason that it has no power to legislate. Your Lordship, the power to legislate has not been conferred on the courts, and the courts cannot add words to a statute or read words into each
But council, we have done that all the time. With our powers under 142, we have done it for inter-country adoption. We have done it for sexual harassment at the workplace. We have done it for numerous. So, too much bridge. What has flown under the bridge for you to claim that?
Yes, Your Lordship, we have done that numerous times, but with regards to personal laws, with regards to Hindu Special Marriage Act, with regards to the, I apologize, with regards to the Hindu Marriage Act, since it confines to personal laws, fundamental rights are.
Council, even Sabrimala, the entry of women was the same argument was made, and it was rejected by this court.
Yes, Your Lordship, but in that same Sabarimala temple case, the dissenting opinion given by Justice Indu Malhotra said that Article 26 cannot be tested merely on rationality of Article 14. And it was...
Which will bind me, the majority opinion or the dissenting judgment?
The majority opinion will be binded. However, numerous courts have also made errors in making their judgments as well. And the dictum made by Justice Indu Malhotra was deemed by numerous jurists to be the correct dictum as well. Your Lordship, so therefore, in light of the above contention, we submit, counsel for the respondents submit that it is crystal clear about the intention and the objective of the legislature in solemnizing the male to female binary, and whereas it only envisages a heteronormative union, and same-sex marriages fails to correspond with the basic definition of marriage given under these two acts, Hindu Marriage Act and Special Marriage Act. Your Lordship, asking permission for this court to put forth the second contention.
Please.
Much obliged, Your Lordship. The second contention that counsel for the respondent submits is that civil rights cannot be granted to the members of the community in such a way that pervades Article 26 of the Constitution. Your Lordship, we humbly submit that even though citizens of Reglamento are guaranteed the right to equality before law, are guaranteed the right to equality, the right to equality, they are granted protection from discrimination on grounds of religion, on grounds of race, on grounds of sex. These rights are not absolute. Article 14, 15, and 21 are not absolute, and they are subject to reasonable classification. And it is the submission of the respondent that being not absolute and being subject to reasonable classification, it cannot hamper. These rights cannot be used, cannot be carved out by the rainbow community so as to hamper and impede and to undermine Article 26 of the Constitution. Your Lordship, personal laws do not derive their validity on the ground that they have been passed or made by legislature in India, in the Republic of Reglamento. Taking into consideration the heteronormative states of the Republic of Reglamento and the sanctity of personal laws, to the extent that right to manage religious
Also,
affairs.
the sanctity of personal laws has been interrupted by this court on numerous occasions. Shaira Banu, from
Yes, Your Lordship.
and we have taken upon ourselves that what is an essential practice of the religion. We will even adjudicate on that.
Yes, Your Lordship.
Right. So this cannot be claimed the protection, the discrimination against same-sex couples cannot be. No religion has claimed that that is part of its essential practice.
Yes, Your Lordship. When we look into Shaira Bano case, right to triple talaq was the issue, the contention there. Triple talaq was struck down, was held to be abrogative of Article 14 because it is a social evil. Social evils such as sati have also been abolished. However, are we going to deem that marriage, the observance of marriage between marriage between a man and women, are social evils? No, Your Lordship. They have been deemed to be a part of these personal laws. They have been having enjoying to be an integral part of the relationship of the Hindu personal laws, much to the extent, much before the codification of the Hindu personal laws, right before Article 1955 of right before Article 1955, these observances have already been practiced. It is an integral part of this religion. And just because it is being questioned on the right to equality does not mean that it should pervade protection under Article 26, the right to manage religious affairs. This observance, it cannot be undermined, and the
But how can
sanctity is
this
there.
be said to be a religious affair?
Your Lordship, could you please repeat the question?
How can this claim to be a matter of religion? Because there is no religion which positively discriminates against gays or lesbians.
Yes, Your Lordship. There is no religion which expressly discriminates against this community. However, in its current form, in its present form, it cannot be read so as to include these members. Did I satisfy Your Lordship?
Yeah, please move on.
Your Lordship, asking permission to this court for my co-counsel to put forth the third argument.
Yeah.
Thank you, Your Lordship. The third major argument that the counsel for respondent have put forward is that now the custom, traditions, right, rituals form an exhaustive code. Your Lordship, due to the customs of heteronormative institutions, the customs, traditions, right, and rituals of religion in Republic of Replemento form an exhaustive code, so as not to include members of the LGBTQI community. This was practiced since time immemorial, and Your Lordship, this cannot be abrogated merely on the basis of right to equality, which is not absolute. Your Lordship, we live in pluralistic society and secular polity. Constitutional morality would reflect that the followers of various sects have the freedom to practice their faith in accordance with the tenets of their religion. This may be irrelevant whether the practice is rational or logical. Your Lordship, notions of rationality cannot be invoked in matters of religion by court. Religious customs and practice cannot be solely tested on the touchstone of Article 14 and the principles of rationality which have been embedded. Your Lordship, equality and non-discriminations are certainly one facet of constitutional morality. On one hand, the respondent has also submitted that there is a requirement of equivalence to be struck between the principles of. Yes, Your Lordship.
Yeah. Please go on.
Thank you, Your Lordship. There is a requirement of a balance to be struck between the principles of equality and non-discrimination. And Your Lordship, the protection of the cherished liberties of faith, belief, and worship guaranteed by Article 25 and 26 to persons belonging to all religions in a secular polity on the other hand. Your Lordship, the Honorable Court dictum in Indian Young Lawyers Association versus the State of Kerala, Justice Indu Malhotra has stated that constitutional morality requires the harmonization or balancing of all such rights to ensure that the religious beliefs are belief of none are obliterate or undermined. Well, and
Counsel, can I take you to Article 25, subclause 2, please?
yes, Your Lordship.
Okay, first it says freedom of conscience and the right to freely practice, profess, or propagate religion, right?
Yes.
Then 2 says nothing in this article shall affect the operation of any existing law or prevent the state from making any law, regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice.
Yes, Your Lordship.
I think in Satyam already it has been held that marriage is a secular activity. Right, in that 94 or 95 judgment in Satyam, this thing, and there is also a positive direction under Article 44, if I'm not mistaken, for enacting a uniform civil code. Right.
Yes, Your Lordship.
So since Parliament has not done it for so long, I mean, the community has been quite patient. So they do want some movement in that direction.
Yeah, yes, Your Lordship. As I mentioned earlier, in the case of Indian Young Lawyers Association, Justice Indu Malhotra has stated that constitutional morality requires the harmonization of balancing of all such rights. So, if the LGBT community also want to claim their rights, it is very how would I say, it is an ordinary thing, but as if it violates others others' right, I think it would be unconstitutional.
Whose rights is it violating?
The rights of others who are
Two consenting adults want to marry.
Yes,
right? There is nobody else's right. The freedom of religion vests in them. They think that their religion permits them to get married.
Yes. Well, Your Lordship, such their respective religion of the Republic of Replemento does not permit any LGBTQ community members to marry in accordance to their customs or tradition. So if they want to get married in accordance with their respective customs or traditions or religion, they violated that their religious doctrine.
Yeah, but the two people who are getting married are, I mean, they are consenting, right?
Yes.
So they are not claiming that I mean, some person must marry them, or some particular church must permit them, or this thing. They are choosing to get married. They will find a priest who is willing to get them married, and this thing.
Yeah, but
What is the union's objection to that? Already, I mean, the HGTV 377 case also was not very vehemently contested by the union, right?
yes, Your Lordship.
It was only private groups which were contesting the petition. So, why is the union opposing this in such a strong manner?
I apologize, Your Lordship. I think council doesn't know the answer of that.
Okay. Okay, proceed to your next contention.
Thank you, Your Lordship. Your Lordship, well, the constitutional bench in Acharya Maharaj versus the state of Gujarat observed that it is a duty of the court to strike a balance to ensure that fundamental rights of one person coexist in harmony with the exercise of fundamental rights of other. Your Lordship, counsel asks permission of the Honorable Court to proceed with the fourth and final argument.
Yeah.
Thank you, Your Lordship. The fourth major argument that the counsel for respondent have put forth is that members from the Sikh community cannot be allowed to be married as per the rituals of their respective religion. With regard to Hindus, Sikh, Jains, and also Buddhists, which are governed by the Hindu Marriage Act 1955. The wording bride and bridegroom under mean same-sex marriage as mentioned in Section 5 of this Act. It implies notions of marriage to men and women only. Here, the word bride indicates a biological woman, and the word bridegroom indicates a biological man. Thus, if we go through the Indian Christian Marriage Act 1872, which governs the the Christian citizens of Replemento, even though not explicitly define marriage as union between a man and a woman, Your Lordship, it underlies a heterosexist assumption in the notions of marriage. So, furthermore, one of the cores of Christian teachings is procreation, and religious scriptures thus oppose homosexuality, which is evident in the Holy Bible. And also, Your Lordship, homosexuality is a sin in the teachings of Christianity, which can be seen in many verses of the Holy Bible. However, Your Lordship, Muslim marriage is governed by Islamic law, as we all know, which regard the notions of marriage as a contract. Such civil contract is meant to legitimize sexual relations for procreation, and hence, even though there are no express provisions indicating a union between a man and a woman, the purpose of such contract underpins a heterosexist union. So, Your Lordship, the respondent have submitted the dictum of the Honorable Court in India, in Indian Young Lawyers Association versus the State of Kerala. The Justice Indu Malhotra states that a religious denominations or organization enjoys complete autonomy in matters of deciding what rites and ceremonies are essential according to the tenets of that religion. The only restriction imposed is on the exercise of right being subject to public order, morality, and held under Article 26. Hence, the respondent have contended that members of the LGBTQI community cannot be allowed to marry under the ambit of personal law. So, Your Lordship, Counsel asking permissions of the Honorable Court to proceed with prayer.
Please.
Thank you, Your Lordship. Therefore, in the light of the issues raised, arguments advanced, and authorities cite, it is humbly prayed that this Honorable Court may be pleased to declare that the Hindu Marriage Act 1955 and Special Marriage Act 1954 cannot be read in manner to include members from the LGBTQI community. And
Counsel, the respondents must always only seek to dismiss. Okay, you don't have to ask for positive directions from this court in your prayer. I think you made the same mistake in your memorial also.
I apologize, Your Lordship.
Yeah. Okay. Any rebuttal?
Your Lordship, the Constitution rebut, permission to rebut. There are 4 points, Your Lordship. Your Lordship, first of all, the respondents are referring to the dissenting opinion, Justice Indu Malhotra, every
That's
time.
fine.
Your Lordship, secondly, Your Lordship, they have vehemently placed the reliance upon the Article 26 of the Constitution. Your Lordship, that is not even applicable in the present case, Your Lordship. Your Lordship, this Honorable Supreme Court, the Constitutional Bench of Honorable Supreme Court in Subramaniam Swamy versus State of Tamil Nadu in 2014 held the object and purpose of enacting Article 26 of the Constitution is to protect the rights conferred therein on a religious denomination or a section thereof. There is no right over any religious domination to oppose the homosexual marriages, Your Lordship. Your Lordship, also, they have also talked about the reasonable classification. This is our contention also, Your Lordship, that there is no reasonable classification. You are discriminating us on the basis of the sexual orientation only. Also, Your Lordship, a judgment which has been relied upon by the respondents is actually in favor of the petitioner. This is the Acharya Maheshwari versus State of Gujarat case, which says that it is a duty of the court to strike a balance and ensure the fundamental right of one person coexist in harmony with the exercise of the fundamental rights of others. There is no material on record, Your Lordship, which says that heterosexual couples have any issue with the solemnization of homosexual marriages, Your Lordship. It's a private affair.
That's not technically correct because the majority will still object.
Your Lordship, then the reliance would be placed upon the K.T. Puttaswamy, case Puttaswamy judgment, in which it was categorically stated.
Puttaswamy dealt with privacy. That's why 377 could use privacy to justify. But marriage is not a thing of privacy, right? It is for something for letting the world know that the relationship is.
Your Lordship, the Constitution strives for the substantive equality, Your Lordship. Your Lordship, meaning thereby that there cannot be any difference, Your Lordship, on the basis of any sexual orientation or any private affair. Also, Your Lordship, I would also like to refer again to this observation of Justice Chandrachud. That was a very categorical observation that majoritarian view cannot dictate the rights and liabilities of the community which is minor in number, Your Lordship. Your Lordship, it's a democracy. We are living in a democracy. We have to protect the rights of minority. I'm not saying the minority in context of the class or on the basis of the religion, but we're minority in the number. It has to be, we are to be protected, Your Lordship. With this, Your Lordship, the council rests the rebuttal.
Yeah.
Asking permission of this court to put forth the rebuttal.
Yeah. Limited to their rebuttal, huh?
Much obliged, Your Lordship. To summarize all of our contention, we have submitted the dictum made in state of Gujarat versus Mirzapur Moti Qureshi Kasab, a 7-judge bench. In this case, Chief Justice of India, Lahoti R, said that...
Cow slaughter, right?
Yes, Your Lordship. The interest of a citizen or section of a community, howsoever important, is secondary to the interests of the country or community as a whole. Your Lordship, counsel for the petitioners have stated in their memorial in issue 1 that it is clear that LGBTQIA can identify themselves as a man or a woman. This goes against their contention. They are contradicting themselves. These members of this community does not either identify themselves as man or a woman, Your Lordship. Furthermore, in paragraph 4 of their first contention, they have read down, it is submitted that the non-inclusion of members of this community in the legislation in question is irrational and fails to pass the twin test of Article 14 and put reliance on DS Nakara and others versus Union of India. Whereas in this case, none of the LGBT, it does not relate to the LGBT community. In this case, even in this case, the dictum was held that the fundamental principle is that Article 14 prohibits class legislation but permits reasonable classification. Your Lordship, so they have made an incorrect case reference, wherein none of the community have been referred here. Your Lordship,
Okay,
furthermore,
next.
it is further submitted that the state is under a positive duty to protect transgender classes from all forms of discrimination and have put reliance on the directive principles of state policy article 34, wherein it is a known fact that fundamental rights is our DPSP directive principles of state policy is subservient to the fundamental rights. It is subservient to Article 26 of the Constitution. Furthermore, Your Lordship, counsel for the petitioners have submitted that LGBTQI community, the non-granting of their civil rights lacks rationality and is capricious to the omission to the grant of civil rights to the community in question is illogical and whimsical without any reasonable explanation, and putting it here as if the dictum was made in Sanchit Bansal versus Joint Admission Board, wherein originally this case relates to the process of evaluation of selection of candidates. It does not talk about the LGBTQIA community. And just because the words illogical, whimsical are being used does not mean that they can put reliance in this in any case they want. Furthermore, Your Lordship, they have put forth in issue number 3 that any custom can be treated as a valid one only when the same has been existing since time immemorial without any variance and is reasonable. Your Lordship, it is the contest of the respondents that the observance of marriage between male and female have been observed since time immemorial, even before the codification of the Hindu personal laws, even before the codification of all these personal laws.
The rebuttal was limited to their rebuttal.
Yes, Your Lordship. And finally, our co-counsels have put reliance on Shayaro Bano versus Union of India, wherein this case does not talk about marriage at all. It talks about divorce and triple talaq.
Yeah.
And finally, Your Lordship, our member councils, council for the petitioners have not complied with the rules of the competition by using 8 pages for submitting their arguments, wherein the rule was 4 pages. That rests my submission, Your Lordship.
Lordship, can the council answer to the acquisitions leveled by the co-counsel?
No, there's no more. It's only rebuttals are rebuttal. That's it.
So, Lordship, in the interest of justice, because several allegations have been leveled that the council tries to mislead the court by quoting the wrong judgments.
No, that's fine. That's fine. You had your chances to argue. Okay, that's yeah. Mansi, I think I've entered this thing. Can the totaling be done by somebody there?
Yes, sir.
Yeah. Okay, if you just do the totaling, then I can see the score once before you announce it. Right. Okay, can I just give some feedback in the meanwhile?
Yes.
Okay, we were asked to give feedback before this thing. See, one is, I mean, the topic is such that it becomes a debate, right? But this is a moot court competition, so you have to found each proposition in specific legal provisions, right? And I mean, the basic the tenets of how do you use precedent? How do you use a proposition from a previous judgment? How do you cite it, right? All those are important. So I think you should have, I think that there could be improvement for that. Okay. And don't, I mean, in a case like this, I mean, one side sympathies will always be more, right? But for the other side, there will be arguments. So you have to find legal propositions. Like, for example, for the respondents, you should find legal arguments saying that a court cannot interfere in matters like this. There are plenty of precedent for saying that what kind of matters a court can intervene in, right? So that is where you have to fix your argument. You have to choose a center point for you to fix your argument. You should not go to the petitioner's strength, because the petitioner's strength will be the judgment saying that it's decriminalized in Navtej Singh Johar, it's been decriminalized. So what is there, this thing? Equality is a strong this thing. How can one set of couples be given the right to marry and all the civil rights which flow from it, and another set of couples be denied that, right? But don't argue on their strength. You argue on your strength. Your strength is, can a court intervene in such a matter? And will it not cause confusion, right? So this thing, speakers 1 and 4, I have to, be a little more confident in answering questions. Don't get nervous, because see, my job is to ask questions, right? So I'm going to ask you questions to this thing, to try and wrong foot you, right? Be more confident in your answers. Don't think that I'm saying it or I'm this thing. So this thing, you should be very clear about your arguments and your grounds, where you're footing, and you must keep me there. This is applicable to moot courts and in real court also. You keep me to where you want to go, right? I will only throw questions at you. So keep me in the area where questions are comfortable for you. Okay, I will try going out in a tangent. It's your job to bring me back to where this thing, right? Where you are more comfortable. And then that's all of you have to be a little careful in not letting this descend into a debate, right? It has to be founded on legal principle. 25, you take the words of 25. That answer was the one I was looking for. Subject, both 25 and 26 become with subject to this thing. There's a lot of debate in the Constituent Assembly about why it was done, right? They said that every practice will claim the protection of religion, untouchability. Every social practice will claim the practice of this protection of religion, and we will not be able to do any social reform, right? Things like that. Now, and the other thing is, in your fact sheet, you are given the basic facts, but from this it flows that you should be very confident about what are these civil rights, what do they entail? What is adoption? How will reading it as person affect each one of those legislations? That will be very helpful if you have those, if you have this thing, because from my point of view, it would have caused a lot of confusion, right? If you read persons in a marriage legislation as male or female, because I think some of the grounds for divorce also are very specific to gender, right? So those type of confusions, how do you this thing? And then confusion was then domestic violence. All those legislations have to be brought on parity, right? So those are the confusions which will make a court hesitant to intervene in such matters, right? So those are things which should have been argued, should have been studied more further. Okay, otherwise it was a good job. You guys did well, and best of luck for the next round. And now I always tell this to all moot court teams that, see, law, there are no right answers in law, right? An argument has to be made. An argument can be backed up, whether it's from the state or this thing. Your strength is in facts. And in a case like this, it's what they call a brandé brief, right? You have a lot of facts, statistics at your disposal to answer questions. In other cases, in civil cases or criminal cases, it will be the facts of that particular case which are the most important. So the best way to answer a question from a judge in a moot court is always with facts. In a case like this, because it's a more general PIL kind of thing, so you have to have a brandé brief with statistics and this thing to have this thing. Because one of this thing which none of you had answers to was, which I think is the strongest argument in this, which should be debated, is it is a fact that a majority of this country today, if there's a poll taken, a referendum is taken, will not support same-sex marriage. I would go to the extent to say it's almost 90 to 10. right? So after that, you have to found it on the one singular ground of fundamental rights. You have a fundamental right to marriage. Now, right to marriage was rejected by the Constituent Assembly specifically. No. So all those things, if you had explored it, you would have been more comfortable arguing that point. It's arguable for both sides, right? Yeah. So any more questions you guys have? Okay. All the best then.
Thank you, sir.
Have you done the totaling?
No, sir, you will be doing it.
Oh, you want me to do it?
Yeah, yes.
Okay, I'll do it. Okay. Thank you.
Thank you, sir. Thank you, ma'am.
Thank you, sir.
The speakers may leave the courtroom. Mansi, this sir wasn't like sir wanted to say, do the totaling and like tell out the scores in public.
Mm-hmm.
1 minute. There are 2 minutes. So they're not, judges are not allowed to like speak out the scores in public.
Okay, okay. I didn't know that.
Yeah, well, I think that they're not allowed because they are to be like everyone is to be given the chance of like told the official communication only through the official main ID after the totaling is done by the court committee.
Okay.
So no problem. You can leave the.
Shall we go to the session now?
Yeah, definitely.